Hi, everybody. Welcome to True Crime Wednesday. It's that day. And man, oh man, there are some really interesting things to talk about today. And I am not going to recap every small detail that's happening in a lot of the cases that we're following. Instead, we're going to dive deeply into a couple of cases that had some really interesting legal developments that I want to talk at length about because I know y'all enjoy that. You enjoy being able to understand sort of the nuances of some of these cases. I also, before we get really deep into it, while we're waiting for people to join, want to thank everybody who has responded and given me some great feedback on where the program goes from here. Y'all know that I have a new project that I am hoping is going to turn into my next book. And I'm not ready yet to make any grand announcements, but things are moving along. And so, one of the things that you are going to see is a bit of a rebrand on on the channel. The channel originally was titled to go along with the book that I was writing, and it is out now. But it's time to give things a little facelift and do a little rebranding so that where I'm positioned for the next project. So don't be surprised if you see some changes. Things are going to look a little bit different, but same kind of content is going to continue. I will be asking for some more opinions as we go along, just to make sure that I'm headed in the right direction and that it makes sense. So as we go along, look for more changes. The first case I want to talk about today is Delphi. Now, I know there are lots of folks out there saying, oh, trial's over, he's been sentenced, that's done. But it is so far from done. And there is a really fascinating development, and it is memorialized in an affidavit that was filed by the defense attorneys. And I'm going to put it up, and I'm going to do something I don't usually do. I'm going to read this one because there is so much important and legally perplexing, I guess, information in it that I really want to share it with you. So I'm going to pull it up. And because it is a little bit difficult to read from the StreamYard screen, I am going to look over at my other monitor and read it to you because it is it's troubling. So let me see if I can get this pulled up where I wanted it. Actually, I guess I could do it from this. Whoops, don't want that. Bear with me for just a second because I do want to read this. And I'm having trouble seeing it off of my little screen, but we will soldier on here. So I'm just going to move closer to the screen so that I can read it to you. Richard Allen, by counsel, now comes before the court with his verified motion and moves the court to order the state of Indiana to preserve certain specific evidence and to produce that evidence to the defense. In support of the motion, Richard Allen states the following. So this is the affidavit that was attached and is the verification, as they call it, um, for the motion that they filed asking the state to preserve certain evidence. So I do want you to sort of pay close attention to the timeline because it's important. Remember that Richard Allen's trial was in November and December of 2024. So on February 12th of 2005, or 2025, sorry, Richard Allen's counsel, Andrew Baldwin, met with inmate Reese Davis at the Newcastle Correctional Facility. Now, we heard a little bit about Reese Davis in another motion that was made. And one of the things that we heard was that he claimed that Ron Logan, now I'm going to have to back up just a little bit and talk about who all these people are for anybody who's not aware. Ron Logan was a local resident of Delphi, and the girls' bodies were found on his property across the creek from the Monon High Bridge Trail. So Ron Logan was always sort of a suspicious guy. In and out of prison, had a record, not the most savory guy in the world. Had a history of domestic violence, some other issues. So in one of the earlier motions, what we heard was the defense complaining that the door was opened for them to bring in third-party culprit information because on the stand, the medical examiner, for the first time, said, I believe that the girls were killed with a box cutter. Before then, he had speculated two different kinds of knives, maybe one serrated and one not. But it was the very first time that it had ever come out that the medical examiner had now changed his opinion about the mode of death and believed that a box cutter had been used. He testified that he was in his workshop and he was looking at a box cutter and suddenly, boing, the bulb went off, that in fact the injuries to the girls' throats likely were caused by a box cutter, and the imprint that he originally thought was some sort of serrated knife was actually the leading lip edge of the box cutter. So the prosecution, the defense was saying, hey, wait a minute, that was new information, and we want a new trial because that created the connection, the nexus, to the third party culprit stuff. So they then went back out to talk to this guy, Reese is the way he pronounces it, Reese. So they went out to talk to Reese Davis. And during the meeting, Mr. Davis informed Attorney Baldwin of the following. He, Reese Davis, was in the unique position of having met both Keegan Kline. Now, don't forget about Keegan Kline. Keegan Kline was a young guy, this sort of typical oddball broadcasting from his grandmother's basement. And he had created this persona online using the photograph of a male model and connecting with young women. He had been in contact with Abby and Libby. Libby, she was the one that had a phone. He had been in contact with them, and they actually had talked about meeting up that day, which may have been one of the reasons the girls were so intent on getting out of the house and on the trail. So there was there was some indication that they thought they were meeting this male model guy, and actually it was Keegan Kline, who was far from a male model. So Reese Davis was in the unique position of having met both Keegan Kline and Ron Logan during their stays at the Newcastle Correctional Facility. Reese Davis talked with Ron Logan about the Delphi murders on multiple occasions over the course of time Logan confessed to his involvement in the murders, along with 2 other people. During those conversations, Logan provided certain details of the crime that only the actual killer would know, but never divulged who the other 2 people involved in the murders were. In or around March of 2024, now, when the police started looking into Keegan Kline, they never discovered any evidence that he was involved in the murder, but they found many child essay images and in his possession. And so he was convicted, pled guilty, I believe, to the possession of child images. And so he was in jail, or in prison, actually, for having possession of those images. Reese Davis is serving a long sentence, inordinately long, in my opinion, for meth possession. And he was in prison right after the murders with Ron Logan. Now, Ron Logan has since died. He died of COVID during the height of the the pandemic. And so he's not available to corroborate, admit, or deny any of these allegations, but Keegan Kline is still in prison. So Reese Davis had these conversations with Ron Logan in 2017, so not long after the murders were committed, but long before Richard Allen was identified as one of the as a suspect. And so in or around March of 2024, Keegan Kline was placed in the same general area as Reese Davis, and at some point apparently learned that Reese Davis had talked to Ron Logan while Logan was incarcerated at Newcastle. Over time, Kline began asking Reese Davis about his conversations with Ron Logan and whether Ron Logan had ever mentioned Keegan Kline's name to Reese Davis during their conversations. Reese began to realize that Kline may have been one of the other members of the crew that Logan described as having been involved in the murders. Over time, Keegan Kline began to reveal information about the Delphi murders that corroborated the details Ron Logan had revealed. Some of the details Keegan Kline provided to Reese Davis are the types of details that could only be known if that person were involved in the crime. The conversations between Davis and Keegan Kline occurred all the way up to the guilty verdict, at which time Kline expressed his relief that Kline would no longer be a viable suspect due to Richard Allen's conviction. Not knowing whether Richard Allen was the third person involved in the murders, Reese Davis asked Kevin Kline whether Mr. Allen was the third person, and Kline replied that he was not the third person and had nothing to do with the murders. Keegan Kline further revealed to Reese Davis that he and Logan knew each other through the sharing of child images, that they shared on burner phones, and that further that Klein and Logan would see each other every 3 to 6 months. So Klein could assist Logan with using the burner phone because Logan was inept at working with electronic devices. Reese Davis further explained that once Keegan Klein began revealing his role in the murders, sometime in the summer and fall of 2024, so before Richard Allen's trial, he began sending letters to prosecutor Nick McClelland, providing many of the details that Reese Davis of Reese Davis's conversations with Keegan Klein and with Ron Logan in 2017. Reese Davis indicated he believes he sent as many as 8 letters to McClelland's office, and presumed that McClelland was sharing them with the defense. Attorney Baldwin met with Reese Davis on March 27th of 2024 and learned very limited information from Reese Davis, who encouraged Baldwin to watch a videotaped interview law enforcement conducted years earlier. Now, Andy Baldwin went to Newcastle and interviewed Reese Davis in March of 2024, so several months before Richard Allen's trial, because he knew about Reese Davis. He knew that there were allegations, or there were reports that Reese Davis had talked to Ron Logan, and that Ron Logan had confessed or implicated himself in the prison conversations. So Andy Baldwin went to talk to Reese Davis. At the time, Reese Davis wasn't sure whether the Keegan Klein conversations hadn't happened yet, and Reese Davis wasn't sure whether Richard Allen was the third person who was involved or not. So he was a little standoffish, a little superficial with Andy Baldwin when he went out to interview. But he did say, at the time that I reported these things, I was interviewed by law enforcement, and there's a videotape of an interview. Go watch that. That'll tell you everything you want to know. So when in March, when Andy Baldwin heard about this recording, he went back to his office and said, and looked to see whether or not it had ever been discovered to them, and couldn't find it. So he then sent a message to Nick McClelland and said, "Where is this interview with Reese Davis? I want it." And crickets. And with the getting ready for trial, and with the abundance of things there are to do getting ready for trial and discovery to sort through, nobody ever looped back and followed up with Nick McClelland. Now, we're going to talk at length about Brady and about discovery, but Nick McClelland, the defense never had to request that. Nick McClelland had an obligation to provide it, whether the defense asked for it or not. So when the defense asked for it, it should have been provided, and they shouldn't have had to follow up on it and ask for it on multiple occasions. So at their February 12th, 2025 meeting, when Andy Baldwin went back out to Newcastle to talk to Reese Davis recently about what he had, about the conversations he'd had with Keegan Klein, Reese Davis further admitted that when Attorney Baldwin met with Reese Davis in March of 2024, that he did not provide all of the details that he knew at the time for 2 reasons. He had not yet heard of the many details that Keegan Klein ultimately provided that corroborated what Ron Logan had said, including that Keegan Klein was involved in the crime and that he, Keegan Klein, knew Ron Logan. And two, at the time that he met with Andy Baldwin in 2024, Reese Davis couldn't be sure whether Richard Allen was one of the other people that Ron Logan described as being involved in the murders. Mr. Davis stated that he was guarded during the March 2027 meeting with Baldwin because, have I run out? No. He did not necessarily want Richard Allen's defense counsel, if Richard Allen was one of the three men, he didn't want to help them. So I'm just going to skip that part because it's not, it's not really relevant. Following the March, okay, this is the part. Following the March conversation, he reached out, Andy Baldwin reached out to the prosecution and asked for the video. To date, the prosecution has never provided any videotaped Reese Davis interview to the defense or explained why it has not been done. The approximate 8 letters that Reese Davis claims that he sent to McClelland up to the October 2024 trial would contain multiple layers of exculpatory evidence, which the defense could have used to further investigate whether they used to further its investigation as to whether certain facts contained in those letters could be verified. Defense counsel's never seen these Davis letters, didn't know of their existence until after the trial, when the defense counsel met with Mr. Davis in February of 2025. Also, the prosecutors never informed the defense of the existence of any such letters. So on the evening of February 12th, Andy Baldwin left Newcastle and immediately went and sent McClelland an email and asked. The first thing that happened was Baldwin went back to his office and they did a really thorough search to find out whether or not they had received the video or the letters, and maybe they just were hidden in a file somewhere. A lot of discovery. There's huge volumes of discovery in this case that have to be organized and cataloged. And the prosecution has not been great. They buried stuff. Rather than calling attention to something, they do a big data drop, a lot of duplicate documents, and they bury something in it. Different states in different jurisdictions handle discovery differently, but in a lot of states, prosecution is required to flag those exculpatory types of discovery. However, they didn't have those letters. They didn't have anything having to do with Reese Davis and the video, the taped interview, or the letters. So he emailed Nick McClelland and said, "Hey, where are these letters?" And Nick McClelland's response was, "You have everything, and if you want to take it up on appeal, take it up on appeal. But I'm not going to respond." So Andy Baldwin then sent Nick McClelland a message and said, "I just have 2 questions. Did you ever receive letters from Reese Davis? And did you ever discover them to the defense?" And Nick McClelland has not, at least at this point, has not responded. And it doesn't appear that he's going to respond. So as of the time of this filing, Nick McClelland has failed to answer these simple, straightforward questions. The defense has reviewed all the e-discovery, and they can say that to the best of their ability, they don't have it. So the defense is asking the court to order McClelland and any law enforcement agencies to preserve any of those, if they have them, any of those letters and that videotape for the purpose of appeal. So at this point, we have not seen Judge Gall do anything to order that these things be preserved and or asked to have a hearing on the issue. So, but this all leads us to talk about Brady versus Maryland. Now, there are a couple of cases that have some pretty potentially glaring Brady issues, discovery issues. And the other one is Reed, and we're going to talk about that too. But I really wanted to get into talking about Brady versus Maryland, because you hear lawyers talk about discovery and you hear lawyers talk about, oh, that's Brady all the time. So I wanted to talk a little bit about what Brady means. And to do that, we need to have a little bit of background in the case. So here's the facts of the case. This case was decided in 1963. I decided to splurge and have wine, and there was this much left in the bottle, so I have a really full wine glass. But I plan to remedy that. Anyway, the case involved two co-defendants in a first-degree murder case, and their last names were Brady, and Boblit, or Boblit. They were co-defendants who were tried for first-degree murder. Brady had claimed from the very beginning that he participated in a robbery, but not in the murder of the person they were robbing. They were both found guilty and both sentenced to the death penalty. After sentencing, Brady learned that the prosecution had suppressed Bobit's confession that he was the one who committed the murder and that Brady wasn't involved. So the Supreme Court found that it was a violation of Brady's due process that exculpatory information that would have exonerated him or proved his innocence, that not turning over that exculpatory information was a violation of his due process rights. Why is that? Well, it's because the state literally has all the power. They have almost limitless power and resources to investigate crimes. They have resources at their disposal that no defense attorney would ever have. And when they develop evidence, it is incumbent upon them to provide it to the defense. So they have the ability to turn over every stone. In a lot of jurisdictions, Brady has been extended beyond what the Supreme Court ruled. Now, states are always free to give people more rights than the Constitution or a Supreme Court decision might allow. They're just not allowed to give less rights. So they can't give less due process, but they can give more. So in some jurisdictions, Brady has been extended to include evidence that could lead to exculpatory evidence. Now that makes it really broad because often you don't know if something's going to lead to exculpatory evidence until you investigate. So it really does say to the prosecution, you have to turn over everything. Even if it doesn't seem important, even if it doesn't seem like it could lead to exculpatory information, you still have an obligation to turn it over. Now, that little nuance varies from jurisdiction to jurisdiction. But at a minimum, here's what Brady says. The rule says that the prosecutor, whatever we're calling them, some states solicitors, some states prosecutor, some states district attorney, but whatever we're calling them, the state must disclose any evidence that is favorable to the defense and material, regardless of whether the defendant asks for it. So the issue is it material? Now, material is a little bit different than relevance. They're kind of cousins, but they do have a slightly different nuance. So we're going to ask, is it material? Does it go in some way? And really, it's not a huge standard because it's almost like probable cause. It's does it go towards supporting the defendant's case in any way? So material is a pretty low bar to hit. And is it favorable to the defense? So that's the minimum requirement for Brady. Is it favorable and is it material to the case? As I say, a lot of states have expanded that to include any evidence that might lead to favorable or exculpatory evidence on the for the defense. So the issue with discovery, and the reason why the Supreme Court has ruled as it did in Brady, is the simple question of how do you know to ask for something you don't know about? And this case in Delphi is a perfect example. So how did Andy Baldwin know to ask for any inmate interviews with inmates who might have talked to potential witnesses or potential suspects? I mean, that's sort of a attenuated connection to the case. But it's clear that that is relevant material information that is potentially exculpatory for Richard Allen, and it was not turned over. So there are only two possible scenarios. Well, three, I guess. Either Nick McClellan never got that stuff, which is hard to believe, or he had it and he didn't turn it over, or he turned it over and the defense lost it or never could find it. So, and Andy Baldwin, I saw an interview with him, and he just said, if we overlooked it in the thousands and thousands of pages of discovery that we got, that's on us. But we've gone back and looked at all our discovery files, and we can't locate it. We can't locate the video. We can't locate the letters. So what happens? Well, if Judge Gull were being fair, she would likely have a hearing and ask those questions. I'm not sure that Judge Gull is going to do that because the case is over and he's been sentenced. She has the luxury of, at this point, ignoring the motion, and it is deemed denied if she ignores it long enough. Then Andy Baldwin will turn it over to the appellate lawyers, and the appellate lawyers will include that in their appeals process. So either way, it's going to come out. But there are much bigger issues, and that is, if the prosecution actually knew about these and didn't disclose them, is there some kind of penalty or remedy for that? And historically, there hasn't been a lot of punishment for this kind of behavior on the part of prosecutors. And every time it happens and there's no penalty, they get emboldened. And we're seeing discovery violations in many different cases. I have 2 or 3 to talk about tonight. And so it's troubling because it smacks of a level of corruption within the state that denies people their constitutional rights, that denies them their due process. And it's very troubling. If in this case, Nick McClelland failed to turn over that information and Judge Gull simply lets it go, I think that there are ethical obligations um, and other ramifications that could come into play. I'm certain that there will be ethics complaints and bar complaints against Nick McClelland if, in fact, he withheld this exculpatory information. What goes on from there will be up to the State Bar Association and the licensing boards. So, but it's gobsmacking. I mean, how do we get to the place where the people who are tasked and swear oaths to protect and defend the Constitution and to fight for justice now are the people who are obstructing justice and other people's due process rights? That should trouble us all. And we're seeing this more and more. I used to wonder if we were seeing more and more of it just because there are more high profile cases that are being live streamed and that maybe there's it's not that much of it. It just is coming out because these cases are so public. But I don't think so, because we're seeing this same sort of behavior over and over and over again in different states, in different jurisdictions, and in different cases. And it's very troubling. So, the violations of can lead to Richard Allen's trial being overturned and could lead to a dismissal because the trial is already over. We're not going to see an Alec Baldwin style dismissal of the charges with prejudice, unfortunately. But it clearly could win him a new trial. Here's the dilemma. The dilemma is that it would go back in front of Judge Gull. So, unless Baldwin and Rosie and Jennifer O.J. were able to convince the appellate court that Judge Gull is biased beyond redemption, and I suppose that's possible. They didn't do it last time, but there's a whole lot more evidence now than there was even then, the last time they asked for her to be recused. So I think it's possible. So the next one I want to talk about, because we're getting into more Brady, is Karen Reed. So believe it or not, the Commonwealth is still screwing around with these stupid videos from the night of the night of the murder, actually the next morning, I think, when they impounded Karen Reed's car and took it to the Canton Police Department, Sallyport. Now, first of all, they picked up her car with a warrant, and it was snowing. We heard all the stuff about how hard it was to clear up the scene and how somebody got the brilliant idea of bringing in their snowblower, for heaven's sakes, to collect evidence at the scene. And we know that it was snowing. And so they decided, despite the fact that the Canton Police Department had already been told that they were conflicted out of investigating this case because of the number of people in the Canton Police Department that had connections to John O'Keefe, including that they'd all been out drinking together that night before John O'Keefe died. So they were told from early on that they were going to be conflicted out of doing any further investigation on the case other than the initial response. However, they still took Karen Reed's car to the Canton Police Department because they had a covered, ostensibly heated space to examine this car. So the Sallyport area of the police department had motion activated cameras. And it wasn't until initially they asked for video, the defense asked for video, and they were told there wasn't any. And then they were told, oh, well, there's a few little snippets. They got that. Then mid-trial, they were presented with the Sallyport video, which turned out to be reversed and turned out to be exactly opposite of what the Commonwealth said it showed. And it was very suspect. And so after the Karen Reed trial, the state or the defense said, we want all of that video. We want every piece of video for those 24 hours. And we want all of it. And initially they said, oh, we don't have it anymore. Then they said, oh, well, maybe it's on the DVR system at the police department. So Karen Reed's defense team paid to have an expert fly from his office in Phoenix to Canton and go examine the DVR system. What they wanted, and what they have wanted from the very beginning, is the raw recording. So anytime you make a video recording, in addition to the recorded image, sound and image, there's what's called metadata. And that's just the background stuff, how it was, the format it was in, when it started, when it ended, if it's been, when it was saved, if it's been changed. All of that stuff is recorded sort of in the background of a video. And so they went and wanted to examine the metadata. When their expert got there, the IT person who was in charge of Canton was thoroughly perplexed as to why they were there, because she said, we don't have any of it. Later then, so this guy made a useless trip, which they asked the Commonwealth to pay for, and Judge Cannoni denied that. And so then they said, oh, well, it might have been click and drag stored in somebody's iCloud, in some retired officer's iCloud. And they have been trying since before Karen Reed's first trial to get this raw video metadata. And the Commonwealth has given them the royal runaround for all these months. And they keep saying, we just want the raw footage of that 24-hour period. Oh, after Karen Reed's trial, they originally asked whether or not there was any footage, any video footage of anyone outside of inside the Sallyport. If there was anything outside on the grounds. And they said, no, there wasn't. Now suddenly this little snippet of video has surfaced that shows that Brian Higgins, who they said wasn't there, was in fact outside the Canton Police Department talking on his phone at 1:30. So something was going on. And so they have said, we don't want you to give this to us in these little fits and drabs anymore. We want every minute of video for 24 hours around John O'Keefe's death and the investigation of the car in the Sallyport. We want all that information. And the Commonwealth has just absolutely stonewalled them. So then they talk to the IT expert, who says that the files are actually stored on their department video file system. So then, well, Alan Jackson goes to court and says, now I want everything that is supposedly on this retired deputy's iCloud account. And they agree with the Commonwealth after the last hearing that the Commonwealth is going to download all that and give it to them. So that's going to happen. So then Alan Jackson gets a hold of Hank Brennan, who's the special prosecutor now, and says, we were just told that by your own law enforcement IT person, Miss McLaughlin, who is in the courtroom at all of these different hearings, running all the audio-visual stuff, that the files were actually stored on this department video file system, and that's what we want. And so then the Hank Brennan says, oh, no, we had a deal that we were going to copy that stuff off the iCloud if it exists, and we were going to give it to you. And if you want anything else, you have to file a motion. So Alan Jackson files a motion. And they go to court and they have this hearing. And Alan Jackson stands up and says, all we want is this audio file, which we are absolutely entitled to. One of the other things that happened after Karen Reed's last trial was suddenly this piece of video surfaced that shows somebody backing. In all the video that we've seen, when Karen Reed's car comes into the Sallyport, it comes in nose in. And just recently, they turned over a piece of, again, another little snippet of video where it shows them backing Karen Reed's car into the Sallyport. Now, Alan Jackson says that information is clearly exculpatory and was withheld from Karen Reed's first trial. And they want it, plus all the metadata. And so what they also want is the audit trail. They want to know every hand that touched that video. And typically, there is a chain of custody log that accompanies every piece of video. But it appears that that didn't happen with this video. It should happen with every piece of evidence, but it appears it didn't happen with this video. So, and Brennan says, I'm not going to create something that doesn't exist. So Brennan gets up there and he is, first of all, his voice just bugs me. He's whiny. He gets up there and says, they're just trying to make the Commonwealth look bad. And he says, this is a quote, I no longer have the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence when you have an agreement and you try to help the other side. That the memory of the discussion is going to be portrayed accurately. First of all, this is not help. He's not doing the defense a favor by providing them with this discovery. He is legally obligated to turn over every piece of discovery that is potentially exculpatory. And there is no question that this is potential exculpatory material. So Alan Jackson said the video of them backing her car into the Sally Port is clearly exculpatory. Now, we don't know what that video shows, but I suspect it shows that the tail light that they claim was shattered and left shards of tail light all over the yard, the McCabe's yard from hitting John McCabe, was still intact when they backed it into the Sally Port. So they are continuing to make this, and it's absolutely shocking to me because Hank Brennan is a defense attorney who was brought on as a special prosecutor in this case to help out. It's shocking to me that he claims that they were letting, he was doing them a favor by letting their expert come. And it wasn't his fault that the expert didn't find anything. It was all sort of out of the goodness of his heart. And what more can we do than invite them to come into the Canton Police Department and look for themselves? But when the defense did, they couldn't find any evidence of this video on the DVR system. It had been, they say it overwrites every 30 days, anything that's not saved. They didn't reveal that they had a video file system and that it was saved there. So, and it appears that this video file system is a discretely different storage device than this retired deputy's iCloud. But there's no way to know because they haven't been allowed access to it. So we're back to Brady. Is it material? Clearly. Is it exculpatory? Looks like it. And do they have an obligation to turn it over? Absolutely, they do. Now we run into some other issues that come up during the hearing. So the first thing is they ask for Mark Betterow, who is a New York attorney, to be allowed to come in pro hac vice to join the team. And the judge says, I didn't receive enough information about the specific benefit that adding Betterow to the team would have to make a decision. So you need to resubmit your motion with more specificity on what it is that Betterow brings to the team. Okay. So, but then Hank Brennan stands up and he says, well, the defendant has a right to hire whatever lawyer she wants, and I'm not objecting to that, but I have thoughts. And my thoughts have to do with the issue of conflict. So I know we have not gotten into this because I have simply not been that interested in it, but there is a YouTube creator. His name is Aidan Carney. It's spelled like Kearney, but he pronounces it Carney. And he goes by the handle Turtle Boy. He claims to be an investigative journalist, and he has been digging deep into Karen Read since the very beginning, and he has been a very verbal proponent of Karen Read and a very verbal, outspoken supporter of her innocence. And he lives in the area and has been accused of harassing or threatening witnesses, including the McCabes and all of the other people that were involved the night of John O'Keefe's death. He has been charged with witness tampering and with witness intimidation, I think. There have been restraining orders, and I mean, it's way more than I really wanted to get into, but that's been going on. And Betterow represents him in that case. He's come in pro hac vice and he represents Turtle Boy. So what Hank Brennan says is that Karen Reed's team has signed a mutual defense agreement with Turtle Boy and his team. Now, this is a little unusual because when you get a cooperation agreement, a mutual defense agreement, it's usually between co-defendants. Now, we know that there is evidence that Aidan Carney had contact with Karen Reed and her defense team. And both cases have protective orders. And so they were using this kind of mutual agreement potentially to skirt the protective orders. And so Hank Brennan's concern is that there is a conflict, and because these are Betterow would be actually what amounts to representing two co-defendants. The defense team claims that they've got that covered, that either there's a waiver or that there's some kind of inclusion in this mutual defense agreement. But they didn't go into it too deeply. The judge took it under advisement and asked them to both submit additional information. She wanted the defense to submit information having to do with specifically what Betterow brought to the team. And they agreed that they would also answer those questions. There were lots, while this hearing was going on, there were lots of comments on the live stream about the demeanor of the defense team, that Karen Reed was laughing, that they were laughing. And you know, this is a long case. This case has been going on forever. These people have been in this pressure cooker forever. And I just thought that it was sort of, I don't know, not unexpected that they were snickering a little bit at some of the things that Hank Brennan was saying. And, you know, I think that there were certainly things that I would have rolled my eyes at too. So I didn't see that what they were doing was particularly surprising or inappropriate, really. They're human beings. But I know that there are a lot of people out there who don't like Karen Reed. They don't like her designer suits because she was a very successful executive before all of this happened. They don't like her demeanor. They don't, you know, so I think that we just need to not focus on that and focus really on what's going on in the trial and whether or not she is getting a fair trial. And to be honest, I kind of have my doubts. Now, one of the motions they filed was whether they could have access to the cars and the driveway to do testing, including 3D scans. And the defense asked the court to hold off on that decision because it appeared that they had gotten some of the things that they wanted from the defense, lo and behold. That there were some 3D scans and some other things that that the state was going to make available. Why it wasn't made available to them before, I think you know the answer. The O'Keefe family, still owns the house that John O'Keefe was living in at the time of his death. And the O'Keefe family filed an affidavit saying they would cooperate if the examiners wanted to come out and do those scans and measurements and all the things that they wanted. So the defense said they were going to have their experts take a look at it, at the data that the state turned over to them, and decide whether it was sufficient or whether they needed to do additional measurements and testing. So which leads us very firmly into the motion to disqualify the guys everybody calls the crash daddies. These are the the experts that were hired by the FBI. Now, this case has been going on long enough, and there were many questions about the investigation, about the law enforcement that were involved, and the FBI got involved to investigate the investigation. And in the course of that, the FBI hired two outside experts, doctor level experts, to come in and analyze all of the crash data, both the data that came from Karen Reed's infotainment system and measurements and data that was obtained through the investigation. And these were the two experts that came in and absolutely demolished Trooper Paul, who was their crash reconstruction expert, who really had very little training, had really superficial sort of crash reconstruction training, and basically was demolished. So what happened was, as time went along and everyone is getting ready for the second trial, the state said, we want all of your files. We want the crash daddies to provide all of the data that they relied on. In addition, they wanted additional information about compensation, contact with the defense, all of those things. Very typical to get that. And very typical when one side has an expert that they are required to provide that. How much did you pay them? How many hours did it take? What did they do? How much communication did you have with them? All of those things have to be transparent to assure that the experts are being experts and being objective. So, but here's the wrinkle in this. Because they originally were hired by the FBI controls all of their findings and files. So in the first trial, the FBI agreed to have both of these experts come to court and testify about their findings, about what they reported. Sorry, I'm shifting in my chair again. About their methodology and report on their findings. So the federal government said, everything that we have done is protected and we're not going to release it. We're going to allow these guys to come and testify and give limited information about all of the background stuff. And so the crash daddies came and testified. So now we get to trial number 2. So Hank Brennan says, if the crash daddies are going to testify, I want more of their files. I want more of the data that they relied on. I want more. I want to know how they were retained, how much it cost, all those things. So the FBI comes back and says, we're not going to give you anything because everything that they did for us is still confidential. However, our contract ended with them. So if you all want to hire them, you can, and they can come and testify to their findings, but we're not going to release any of that information. That's the feds, okay? So now there is this process by which, it's called a TUI letter. You can request FBI information, and FBI will decide whether or not they're going to release that information. So Hank Brennan says, I went and put in a TUI request for, it always sounds like, like somebody spitting, but it's a TUI request. So I put in a TUI request, and the first time they denied it. When I renewed the motion, then they sent me some things. And among those things they sent me were some text messages between Alan Jackson and one of the crash daddies, as well as some email correspondence that included his outline of the questions he was going to ask that appeared to have been annotated by one of Dr. Wolf, I think. It's Wolf and Rensler. And so what's unclear from the information that was provided, so during the original trial, when Alan Jackson presented these experts to the court, he said, I cannot provide anything beyond what I've given the court because it all belongs to the feds. And I've never talked to these people. And the judge said, you're going to put on witnesses that you've never talked to? And he said, that's about right. So Alan Jackson said to the court before the last trial that he had never had any substantive conversations about their testimony, that they had had conversations about scheduling and materials and that sort of stuff, but they never had a conversation about what they would testify to because the FBI said they couldn't. So the trial happened, the crash daddies came, they were incredibly persuasive about the fact that John O'Keefe was not injured by a car. A car didn't hit John O'Keefe. The injuries weren't caused by a car hitting John O'Keefe. They said that a car, Karen Reed's car did not hit John O'Keefe, and John O'Keefe's body did not show injuries from a car. So then Hank Brennan gets up and he says, I think that Alan Jackson misrepresented himself to the court in the last trial because I got these documents that show that there was these conversations about substantive testimony before the last trial. Now, I have some huge questions about this because, and the judge said, I am so concerned about this that I am going to pause this hearing. And we're not having any more hearing. Y'all are going to come back next week prepared to have a conversation about this. That was sort of code for Alan Jackson might want to lawyer up. And but I had some real questions about this. For one thing, the emails that they were exchanging back and forth were not about substantive matters. The only substantive thing was this outline of his questions. And there was no way to know whether it was undated. So there was no way to know whether he was exchanging that outline of his questions in preparation for this trial. And there's no way to know. Initially, Alan Jackson and company, before the first trial, thought that they would need to sign a letter of engagement, basically a retainer, and pay a retainer to this private company that had been retained by the FBI. It turned out he sent them an email and said, please send me your retainer, your engagement contract, and I will send you a retainer. They came back and said, wait a minute, we want to clarify with the FBI first. And it appears that they didn't hire the crash daddies, that they came on the FBI's contract. And that it wasn't until April or after the last trial when the FBI said our contract is ended with them, that they then came in and retained the FBI guys or the experts. So I have some real questions about the timing here. I think it's very possible that they had those conversations about retaining them, didn't retain them. They came still under the auspices of the FBI at the time they testified. And that the communications that Hank Brennan is so convinced prove that Jackson lied are things that happened in preparation for this new trial, for the next trial. I think it's really possible that that's what's going on. I have to say that Alan Jackson is an incredibly accomplished and attorney with a lot of prestige. I cannot see Alan Jackson risking his ticket to practice and his reputation to misrepresent something so unnecessarily to the court. I mean, it really didn't matter whether Karen Reed's people retained them or whether they were still operating under the FBI's contract. They still had the information, had done the analysis, and were available to testify about their findings. It didn't really matter. In fact, one of the jurors said that they were very confused because they weren't told that there was this ongoing FBI investigation because nobody wanted to. The judge thought that would be too prejudicial against the law enforcement officers who were under investigation. And so they weren't able to say these people were hired, not paid by either the defense or the state. But they weren't able to say who hired them. And a lot of the jurors said that they were suspicious of that they thought maybe it was Karen Reed's insurance company, or they thought maybe it was some outside crowd-funded thing with Turtle Boy, or, that it was something that was not reliable. And the one juror I heard interviewed said, if we'd known that they'd been hired by the FBI, I think we would have felt very different about their testimony. So the fact that they were hired by the FBI, I mean, they might have done better if they'd said we're hired by the defense. So I really do not see a world where Alan Jackson knowingly lies to the court and presents information that is not accurate, because, in the grand scheme of things, he's got a lot of career left. It's not like his career is done and he's going to retire. So I don't see him risking that. I think that would be surprising from any reputable lawyer. And I think that Alan Jackson has a reputation of being a very good and very reputable lawyer. So I can't say that I see that as an issue, but it will be really interesting to see what happens when we get back to court next week. I think there's a possibility he comes in with his own counsel and is able to present what actually happened, his communications with the crash daddies, and I think that it will get resolved. Worst case scenario, if it's a misrepresentation to the court, the judge could throw him off the case. And that would be unfortunate for Karen Reed because he's an excellent attorney. So we'll wait to see what happens with that. But I guess I'm too quick to give people the benefit of the doubt. But I just can't see how someone who is as practiced and as accomplished as Alan Jackson risks all of that for basically a pointless allegation. So I am going to touch kind of briefly on Shana Gardner, because once again, some of it involves discovery issues. So I particularly picked these out because I wanted to talk about the discovery issues, but I also I want to talk kind of in depth about this case of Zack Hughes. The victim's name is Christina Purcell, And it has been on YouTube. They've been calling it the rose petal murder. So let me get back to that. But I quickly want to run through some things that are going on with Shana Gardner. So there have been continued pushes and shoves about discovery in her case. So Jose Baez, who I have thoughts about. I have some misgivings about Jose Baez. You may remember Jose Baez was the attorney who represented Casey Anthony and managed to get an acquittal. And his stock has certainly gone up since then. Now, he is claiming prosecutorial misconduct for discovery issues. What happened was, in May of this year, they had a bond hearing, a bail hearing that was denied for Shana Gardner. Shana Gardner is the one involved in a case. It's another murder for hire case. It's a case where it's a murder for hire for custody of children again. She is from a very wealthy family. And so at that hearing on bail, the prosecution presented text messages between Shana Gardner and two of her friends, Kim Jensen and Susan Lee. When they started to present that, Jose Baez insisted that he'd never heard the name Susan Lee before, that they had never turned over the evidence, and that they were getting sandbagged. The prosecution claims that they did turn it over, and that in fact it was in the grand jury notes. It was in the grand jury transcript, because both of them, those text messages, were presented to the grand jury. There was a whole series of text messages between these three girlfriends, a sort of a run, and which Jose Baez painted as a running joke about please murder my husband, or where can I find somebody to murder my husband? So the state accused Baez of unethical conduct for airing his complaints on the courthouse steps before he ever even filed his motion about the discovery violations. So there's still discovery stuff going back there and forth there. He says, the other thing is, there was a police officer that they put on the stand during that hearing who claimed that he claimed that the reason that they didn't bring Susan Lee in was because she had changed her telephone number and they couldn't reach her. It turned out that none of that was true. She's had the same phone number since 2014. And he later said, well, I didn't have my file with me and I may have made mistakes. So definitely sloppy at best. But the biggest news is that a week or so ago, the gunman, whose name is Henry Tenon, who's already admitted and copped a plea and is now recanting his confession. So they went to a scheduling hearing, and during the scheduling hearing, the judge was talking to his lawyer when Mr. Tenon piped up and said, oh, by the way, Judge, my confession was false, and I shouldn't have implicated them. I gave completely false information, and I want to withdraw my confession, and I need a new lawyer, because his lawyer clearly was standing there saying, shut up, shut up, shut up. You don't need to say this. Don't say it. Let's talk about it later. And all the things that lawyers try and do to keep their client from making incriminating statements on the record. Nonetheless, Mr. Tenon did say, I am recanting my confession. It was a false confession. So more to follow on that. But it is an odd case. Now, let's get on to Zack Hughes and Christina Purcell. And this one is going to take a little setup. Trigger warning. This involves child essay. I know I'm trying to be respectful of YouTube's community guidelines. So here's how this all came about. Christina Purcell was married, I think, but I'm not entirely sure whether she was married, to a man named John Mello, with whom she had a child. Child has been named in the trial, so I don't feel bad about saying her name. Her name is Aida, and John Mello was, it's interesting that this is a woman who seems to team up with men who are well off and considerably older than her. So John Mello was considerably older. They had this child together, and then they went their separate ways, divorced or not, I'm not sure. But they had an ongoing dispute over custody of this child. And John Mello repeatedly, CSA, yeah, I know. John Mello repeatedly in family court alleged that the child had been subjected to CSA, and it also involved her mother. So for anybody who's interested in this trial, I have linked Gigi from Pretty Lies and Alibis, Gigi's live streams. This case is taking place in Greenville, South Carolina, which is where Gigi lives. So she has been attending the trial every day and reporting on it, which is super important in this case because it's being live streamed, but none of the sidebars, none of the outside the presence of the jury discussions, any of that stuff is being live streamed. Now, there is a reason for that. So Mr. Mello is deeply concerned that he believes his child is being subjected to this abuse. And they go round and round in family court. He at one point gets custody, or she at one point gives him custody. I'm not really certain. He is billed as a music producer. I don't know how successful he was, but apparently fairly successful. And he was raised or born in Italy, he has dual citizenship. His parents are still in Italy. So at one point, he decides, since he has custody of this child, that he is going to move to Italy with her, and he takes her to Italy. And then there's a big family court thing. Christina Purcell goes back and forth to Italy a couple of times. And between the Italian government and the US government, he's ordered to come back and bring the child back to the US. And now he's doubly, triply distraught that mom is going to continue to have visitation with the child. And he's utterly convinced that she is in danger when she's there. Mom has a new fiance. Everybody who talks about him says he gives off the creep vibe, but so far there hasn't been anything to substantiate the allegations that mother and her boyfriend are involved in any kind of essay with children. So in all of this, John Mello becomes friendly with a guy named Zack Hughes. Zack Hughes is the defendant in this case. I'm telling you what, this case is twisted. So Zack Hughes is an interesting guy. He's 32 now, so he was, I think, said 29 when the murder occurred. And he is a young man who was homeschooled, pretty religious family. He is a very, very gifted classical pianist, and started playing the piano at a young age, had a really real gift for it, won all kinds of statewide competitions, applied to 5 different music conservatories for college and was accepted to 3, went to Juilliard on a very generous scholarship and graduated from Juilliard, and is, by all accounts, an amazing concert pianist. Somehow, and they describe this in the live streams, in his testimony, because he decides to testify. So he explains all of this. He was hired by a symphony, then he was going to join the Marines, and he was doing really well there, but then he got injured and had to leave the Marines and came back, and it was during COVID, and he was kind of giving concerts in the park and, sort of busking, trying to do this concert series of Beethoven's concertos. And while he's busking in the park, he meets John Mello, and his daughter, Aida, is with him. And so he and John Mello get to be kind of friendly, and they start talking to one another. And John Mello, he describes John Mello as a big personality, and that he could be a little overwhelming sometimes, but he was a nice guy. And Zack really, he taught piano lessons to kids, and he had a real heart for kids, and he really enjoyed being around this Mello when he had his daughter with him. And she liked music, and so when they moved to Italy, they had less contact for a while. But then when Mello had to come back from Italy and was so distraught over having to bring Aida back, they started talking all the time. Now, John Mello tells Zack Hughes about Christina Purcell's lifestyle, the fact that she may have been in adult movies, that she may have been involved in sex trade, and may have been, at different times, may have been a sex worker. So Zack Hughes then is trying to comfort John Mello, and he testifies to all this because he decides to get on the stand earlier today and tell his side of the story, and it is mind-boggling. Now, Zack Hughes claims that he did this to protect Aida because she was being abused. After Christina Purcell is murdered, law enforcement discovers in her home devices containing images of CSA involving Christina and the child. They go to a cigar store where the boyfriend, whose name is, come on, somebody put it up in chat, I can't remember it right now, the fiance. And they get a warrant because he's got a locker at this cigar store. And lo and behold, they find a whole raft of thumb drives and hard drives, all of which also have images. in one of Gigi's updates, she talks about the fact that they said there were, I don't know, these devices, there were hundreds of videos and thousands of still images. Okay, Brad Post, thank you. I knew you guys would come through for me. So Brad Post is Christina Purcell's fiance, and they're accused of creating these together. And so after Christina's death, they find all these images, and he gets arrested, and they prosecute him for CSA and for having all the images. So during the trial, early in the trial, they say to the judge, the defense intends to present a defense of self-defense, defense of others. So this is where I want to kind of take a little bit of a deep dive into self-defense and defense of others. So self-defense has a very specific set of parameters. So I'm going to put up our next little thing. First of all, and I have a little clip I'm going to play, and I'm going to sort of pause at different points to talk about. It is the very brief opening statement that the defense made. Now, in this case, the defense decided to defer their opening until the start of their proof, so after the prosecution rested. And he gives a very brief opening statement, and it is mind-boggling, gobsmacking, as the British say. And he talks about malice. So we're gonna talk about that too. But first, I want to get to the issue of self-defense. So in self-defense, you have to start by saying you didn't start the altercation. You believe that you were in danger of death or serious injury, and a reasonable person would have believed that they were in danger in that same situation, and that you had no other choice. Now, South Carolina is a stand your ground state. What that means is you do not have an obligation to retreat. So in some states, part of self-defense is that you have to be literally backed in a corner. You have an obligation to try and get away from the danger. And self-defense is only allowed if it's not possible for you to escape, or you've tried to retreat and you can't. But in cases that have passed stand your ground laws, it means that you don't have to retreat. You can stand your ground. So in 2006, South Carolina passed the Protection of Persons and Property Act, and which extends self-defense in South Carolina to the protection of another person or property. Now, the property part is unusual. Usually, self-defense is only allowed in defense of yourself or another. And in the defense of another, it has to be somebody who's in danger of physical injury or death, and the danger has to be immediate. It's sort of like saying the same parameters apply, except I can act for another person. So let's say I'm in my home and a bad guy breaks in and threatens my child. Well, I can shoot that person, even though that person isn't directly threatening me, because I'm protecting somebody else. But the threat still has to be direct. What you can't do in self-defense, you can't do in the defense of another person. So let me take this down for a minute. We're going to get back to it. But what Zack Hughes says is I was justified because I was defending Aida, and that it was a justifiable defense of others. So the judge looks at all the factors and he says, hang on, let me get this straight. You planned and carried out the murder of this woman because you thought she might be a threat to her child. You never saw the threat with your own eyes. You never even saw any of the SA material with your own eyes. And the child was safely at school. She was not being threatened directly. No, you don't get to make the argument that a defense of others defense. It doesn't apply here. And the judge was well within the law to find that. He was right. It doesn't apply there. It is not like the situation where a parent is protecting a child from a crazed person breaking into their house. It is not even the situation where a complete stranger is protecting somebody from harm, like the subway murder that the guy was acquitted, Daniel Little, maybe? Anyway, that happened recently where the guy was riding on the subway. There was a man who was known to have severe mental health issues who was acting in a threatening manner. There were several women on the subway who felt really threatened. And he stepped in, took the guy down, put him in a chokehold because he was military hand-to-hand combat trained. And as a result of the chokehold and all the drugs that were in the guy's system, he died. Daniel Penny. And Daniel Penny was found not guilty. And their defense was that a defense of others defense. But very clearly at that point, these people felt like they were at risk of bodily harm or death. So the judge was correct in saying the defense doesn't apply here, and you cannot bring up any of the information about the child SA because it is too inflammatory. Now, we've talked about this before. Under Rule 403B, character evidence doesn't come in unless it's to prove motive or a lot of other things. And even at that, the court can say, no, it doesn't come in because it's overly prejudicial to the defendant. So the judge said bringing in that information is going to be overly prejudicial to the case. It could act in a way on the jury that is not appropriate. And so the judge ruled it out and said you cannot bring up anything having to do with the essay. And you cannot raise the defense of others. So now the defense attorneys are really walking a tightrope. They're really trying to figure out how to navigate what the judge has ordered. So the next thing that happens is the defense gets up and they decide to put on this opening statement. And it's gobsmacking. Now, I am going to stop this at different points so that we can talk about some of these things. So,
good morning.
Let me know if you're having trouble hearing.
Now it's our turn.
Whoops.
Thank you, Anna. May it please the court.
I have the volume up.
Good morning, ladies and gentlemen. Now it's our turn.
Mr. Moore and I have been waiting for a long while to be at this point. I was going to say it's been a week, but it's been longer than a week. It's been years. Our client, Zack Hughes, has been waiting for a lot longer than that. He's been waiting over 3 years, some 3 years and 3 months. As Mr. Mormon told you at the outset of this case, we are honored and privileged to be representing Zack. You're going to hear about Zack in the next day or two. You can hear that he's a very gifted and accomplished young man. He is 32 years old now. He was 29 when this happened. He's from a wonderful family. You've probably seen them seated back here in the courtroom throughout this trial so far. You're going to hear a little bit about his life. He was born in California. When he was still a boy, his parents took Zack and his brother, moved him to southwestern Virginia, where they moved into a small farm. And then they took on 5 orphan children who lived there with them. And you can hear that Zack was homeschooled. He learned the value of hard work and discipline as he grew up around the family farm. He helped his young siblings. His family moved to Greenville when Zack was a teenager. In Greenville, he finished high school, being homeschooled still. And you'll hear that his hard work and his discipline paid off. And he was accepted into a very fine college with scholarships. He went on where he studied music, and he won piano competitions. His emphasis was on piano performance. As an adult, Zack has had an accomplished career performing classical music and even recording classical music. So this is the time now for our case and for Zack to testify. But understand, ladies and gentlemen, we have no obligation under the law or the Constitution to be doing this.
So let me just jump in here. First of all, this is the first time that the courtroom is finding out that Zack is going to testify, which is not the norm in a criminal case. The other thing that is kind of interesting is this lawyer gets up and he talks about all the things they could have done in their cross-examinations that they didn't do. We could have done this and we could have done that, but we didn't do it because, and it's a very, very strange argument. Very strange. So let's see what he has to say. Oh, and by the way, I want to say that I took this clip from Long Crime Network. So I appreciate being able to use it. We're using it under the auspices of fair use, but I did, and I want to give them credit for that. They, along with everyone else, are streaming off the pool camera that's in the courtroom. So this footage could have come from any number of streaming of people that are in platforms that are streaming.
This case actually could be over when the state rested. The state has the burden of proof of proving this case in every element of every charge beyond a reasonable doubt. We would not have to put up anybody. Zack wouldn't have to testify. Wouldn't have to put up any witnesses. In fact, if Zack were not here, his honor would instruct you that you couldn't use that against him. But we are going to do so. And Zack is going to testify because Zack has been waiting for this opportunity to tell a group of people like you what really happened, which is that he took the life of Christina Parcell. And crucially, he's been waiting and wanting to tell you why.
Okay, I'm pretty sure that when he said that, you could have heard a pin drop, and I'm sure that the jurors' jaws were open, kind of like, and everybody else in the courtroom. You are you are gobsmacked, just your jaw hanging open. And so now he's going to, he has just, after all of the evidence has come in, the prosecution has put in, the defense just stood up and said, my guy did it. It's inconceivable when the defense that they really wanted to bring in, they can't bring in. The judges ruled against them. But as you're going to see, Zack Hughes doesn't really care about that at this point. It's kind of like he doesn't have anything left to lose. So let's go on.
Now, the why to a case like this is very important because it goes to the heart of the matter, and that is malice. Okay, malice is what makes a homicide a murder. And we heard from that from the prosecution's opening, as you recall. The prosecution said that Zack was mad. They said he had an angry heart, that he wanted to inject himself into this custody dispute of somebody he knew. But that's not why it happened. And that is not what you were going to hear about why this happened. Now, as we turn to our case now, it's important to realize that we could have handled this case extremely differently. Okay, we could have attacked the sufficiency of the state's case.
So here we go. Woulda, coulda, shoulda. Why didn't they? I mean, any defense attorney is going to attack a case from every angle. You have to attack the sufficiency of the state's case. Often that's all you have. Often all you have is to poke holes and to raise reasonable doubt. That's your job. But this guy's saying, oh, well, we could have done that, but we didn't because we just think that what he did was justified. Essentially, that's what he's saying. So
we could have brought in an expert to talk about the DNA. Okay? We didn't do that.
Her DNA was found under, or his DNA was found under her fingernails. If you really want to hear a chilling account, his testimony, and I'm not going to play it tonight, but his testimony, he goes through and tells the jury exactly what happened, and he admits that there was a struggle and that he was worried that she had scratched his face, and indeed they found his DNA under her fingernails. So
we could have challenged the identification evidence. And I want you to consider the professional from law enforcement, from the state law enforcement division, who testified about the enhancement that they did on the videos and the photographs, and how they were able to use this fancy technology to enhance and to account for the differences between sunlight and shadow and the distance. And after all of that, and after all of the technical work that was done, the conclusion was that the guy on the bicycle was 6'5", a big guy like him. Well, as you probably noticed, and as you will see, Zack is shorter than I am. On a good day, I'm 10 foot. I'm 6 foot, 5 foot 10 inches. Okay, he's shorter than.
Okay, the guy doesn't even know how tall he is. However, they obtained Ring doorbell footage of him riding his bike up to Christina Purcell's house. In his testimony, he admits he put his bike in the back of his pickup truck, drove to a location that was within biking distance so his car wouldn't be caught, and rode his bicycle to her house. So, and there was Ring doorbell footage caught of him riding his bicycle in the neighborhood.
Consider the other professional. There's one who spent a great deal of time looking at the enhancement of the person on the bicycle. And after all that time, what was that conclusion? That this person had a beard. It has to be a man. And they enlarged it, and they used, again, all of that technical information to take a look at it. This guy had a beard. This is before they had any suspects. Well, what do we know about Zack and what we learn about Zack? He was clean shaven. We know that from a couple of days prior, and we know that from a couple of days after. We could have attacked that. We could have attacked the identification from the neighbor. As you remember, a neighbor, after 3 years, came into court, and all of a sudden, after 3 years, was able to identify the man whose picture had been on television for the past 3 years. Had never told anybody even that she could identify somebody.
Thank you. May it please the court.
Okay, so this attorney goes on to talk about the fact that there was no malice involved in what Zack did. That he had to act with malice, meaning that he had to have oftentimes they call it a malignant heart. But the statute really just says that he had to specifically intend to commit the murder. So this defense attorney goes on to posit that his client is not guilty because he was justified, that he wasn't acting with malice. He was acting out of the goodness of his heart, that he had a pure heart and he was just defending this child. Now, the defense attorney does not talk about the fact that that there is a child that he is defending. He just says Zack didn't act out of malice, and so thereby this wasn't a murder. So I guess this is sort of like saying if you act as a vigilante, think of Luigi Mangione, who gunned down the healthcare executive, because his intentions were good. Acting as a vigilante was okay. So that's basically what this attorney is saying. It's okay because he didn't have an angry heart. He didn't have a malignant heart. He was acting out of the goodness of his heart. That I mean, so there's a joke among defense attorneys that there are some arguments that you have to put a bag on your head to go to court and make. And in fact, when I was practicing, we had a fellow who really didn't have any shame. He would go to court and he would make these just absurd arguments. And, you know, most of us would go, oh my God, that's so embarrassing. I would never go to court and make that embarrassing argument. But you know what? Every once in a while, he'd win. And he had the best track record of anybody because every once in a while, he'd make one of those wild ass arguments and he'd win. So, this is crazy. This attorney standing up in front of this jury and saying, this guy did not have an angry, malignant heart. He was not acting out of malice when he murdered this woman. He was acting out of pure intentions. How do you make that argument? Now, moving on, which I'm not going to play, because I really wanted to talk today about legal issues and not so much about the substance of the testimony. But if you get the chance, Gigi McKelvey, Pretty Lies and Alibis, has been covering the case. She's been doing updates because she's been in the courtroom. So when the cameras are off or are turned on the seal, so that we can't see what's going on in the courtroom, she's been there. So she's been reporting on those as well. So those off-camera discussions, legal discussions that have been going on, she's been able to report on those as well. So if you really want to see this guy's testimony, and it is worth seeing, it is wild. I mean, wild. So, I mean, it's a couple of hours. You can do it at 1.5 speed and get through it pretty quickly. They take a fair amount of time sort of building out his character, his education, what a great guy he was, how talented and artistic he is, and all of that, before they finally get to the heart of the matter. So he says, first of all, he says that Christina Purcell committed SA on her daughter while he's on the stand. Now, the judge has already told him, you can't say that, it's off limits. You may not bring that up. I'm ruling that it cannot be talked about. And so the first time he says it, the prosecutor jumps up and objects, and the judge says, we need a recess. They send the jury out. And according to Gigi, he is admonished that he cannot say those things. He's already been told, you cannot say those things. Yes, sir, I understand. And so the second time he says it, the prosecutor jumps up and very loudly, very angrily objects. The judge sustains the objection, sends the jury back out. They go off to lunch. They don't come back until after lunch. And after lunch, I take that back. The first objection is before lunch. They come back after lunch. He then mentions it for a second time. So during his testimony, he also says, as part of this description, that John Mello is continuing to be distraught over what he sees as a threat to his child. And at one point, he asks Zack Hughes if Zack Hughes will kill Christina for $5,000. And Zack Hughes says, absolutely not, I won't do that. And then he comes back at a different time and asks him, well, will you do it for $10,000? And Zack Hughes then answers, no, I wouldn't do it for money. I would only do it if it were absolutely necessary to protect Aida. That draws another objection. And at that point, the judge sort of says, you're putting your toe over the line. Don't do that again. So twice during the direct, he says that mother was directly responsible, and had committed SA on her child, and that they had been filming it and creating videos. So the second time he's admonished, it was clear that he didn't agree with the court's ruling, but he said, yes, Your Honor, okay. So then his lawyer asks him to recount what happened that day. And he goes through it in excruciating detail, what he did, what he was thinking, and all of that. Here's the really interesting side note, is that within an hour of him testifying that John Mello had offered him money to kill Christina, John Mello was arrested. And he is currently under arrest. And in fact, I was texting with Gigi, and she said she was on her way to his bond hearing, which of course he's not going to get bond. So that was fascinating. Now, John Mello has had the custody of the child since Christina Purcell's murder. So now she doesn't have either parent, like Shana Gardner. Now she doesn't have either parent. So as the defense attorney is wrapping up, he says to Zack Hughes, did you take Christina's life? And Zack Hughes says, this is a direct quote, yes, because I believed it was absolutely necessary to save Aida's life, and I was right. And the judge turns around and says, disregard that. You may not consider that. So he then, that's at the beginning of his description of the crime. And the judge admonishes him, tells the jury to disregard this. I mean, this is the third time now that he has said that Aida was in danger because her mother was subjecting her to SA. We all know it's true because the boyfriend is serving time for the images that were created and that he had possession of. So we know it's true. But the judge has said to the jury for the third time, trying to unring the bell or put the toothpaste back in the tube, disregard that. I decide what comes in and what you can consider, and I'm telling you, disregard that. So he then gives all of these details of the murder and very excruciating details. It's really hard to listen to. If you're at all sensitive and squeamish, fast forward through that stuff. But the interesting thing is, at the very end, his attorney asks him sort of the question of why or what did you hope you would accomplish? And he says, I wanted to make sure Aida would be safe from the sexual abuse that her mother was perpetrating on her. And there's proof of that the state is hiding from you. Of course, the courtroom erupted. The prosecutor's on his feet yelling, the judge is yelling, the whole courtroom erupts and cuts off, because now everybody's got to have this conversation. So the judge is angry. We're not entirely sure what's happened, although it appears that the judge asked the prosecution if they wanted a mistrial, and the prosecution said no. And we can talk about why that is. But the live stream stops. There's all these objections, and everything goes shut down for an extended period of time. When they come back on, Zack Hughes is back on the stand, and his attorney has a handful of other questions to ask him to get through all his questions. But here's the interesting part. The attorney gets up, and the first thing he says is, isn't it true that? Now, anybody who's studied trial procedure and the way that trials work isn't it true that, or some variation of that, is what you ask on cross-examination. So why is his lawyer now asking those yes or no, isn't it true that questions? Because typically lawyers on direct are asking open-ended questions that the witness can tell the story. And it's cross-examination, you are limited you can ask leading questions, but that is for the purpose of eliciting those yes or no answers. So why is his lawyer on direct asking leading questions? Well, the only time that you can ask leading questions on direct is if a witness is declared to be a hostile witness. So the judge has determined that Mr. Hughes is a hostile witness so that his attorney can only ask those yes or no questions, and he does not have any room to wiggle in any of that other information. Now, the judge has once again given the jury instructions that they are not allowed to consider those remarks from him. So I think, and I think it's clear because the judge asked the prosecution if they wanted a mistrial, that this was mistrialable. This was definitely grounds for a mistrial. So why wouldn't the prosecution want that? Well, there was some speculation that it had something to do with double jeopardy. It doesn't. Double jeopardy attaches at the time that the jury is sworn in. However, if the judge declares a mistrial, jeopardy no longer attaches. So, like the Karen Reed case, where the judge said, I'm declaring a mistrial because the jury couldn't reach a verdict. It's not with prejudice, and this case can be retried because jeopardy doesn't attach. The trial was never completed and ended in mistrial. So jeopardy would not attach in this case if the judge declared a mistrial for misconduct. However, I think the prosecution felt like no matter what they do, this guy's going to do this. He has nothing to lose. He wants his story told, regardless of, he's a zealot. And he wants this story told because he wants people to believe that he did this out of loyalty, out of being a white knight, rescuing this child. And if he has to suffer the consequences, then he says, I did the right thing. So the prosecution, I'm sure, feels like there's no way that it's going to be better next time. If anything, it could be worse because this guy now knows what to expect in his testimony and now knows how to get this stuff in. So what's going to happen? So there are a couple of alternatives. The prosecution could say, we want a special jury instruction instructing them directly not to consider any of the information that they heard, that none of that information is reliable or however they want to phrase it, and that they should not consider it. And, you know, it's unringing the bell. How do those people who heard that information, shocking information? I mean, Gigi talked about the fact that these people were stunned. I mean, their jaws dropped open. How do they forget that? I mean, it's just not human nature that it's not going to be considered in some way, even subconsciously in the back of their mind. I mean, it's next to impossible to see what how they unthink that. So the other alternative is for the prosecution to say, okay, they opened the door, here's all of it. Yes, she was involved in sex abuse. Oops, essay. Yes, she was involved in creating images of her own child, potentially one other victim. Yes, she was involved in sex work. Yes, the co-defendant who actually came to the boyfriend who was in court and testified. Yes, he's a bad guy. Yes, it's all true. Even though that's the case, what he did does not fall into any category that would excuse murder. What he did is not defense of another. What he did is not excusable on any level. He planned it. He figured it out. He worked out the distances in his truck. He figured out, he took a gun that he tried to build a silencer for and it didn't work. He went equipped, he planned, and so you have to convict him on his own admission that he did all those things, because nothing that you have heard could justify what he did. So the prosecution's got a thorny kind of decision to make. Now, it's still possible because everything stopped at that point, and the judge said, we're not going to come back until 10:30 tomorrow morning for a variety of reasons. They're expecting snow in South Carolina, which is real rare, all across the South. And so they're worried about that. And he also said, I need time to hear motions. So they're not going to start until 10:30 their time. The judge has ordered that the live stream be delayed by 30 minutes. So we're not going to see anything until 11 o'clock their time, unless we get updates from Gigi. In the meantime, the prosecution could mull over their options and come back to the judge and say, we changed our mind, we want a mistrial, because they didn't put anything on the record about whether or not they were voting for a mistrial. So none of that's been on the record yet, and they could come back and say, we want a mistrial. But from a legal standpoint, this is a thorny, strange case. I mean, as a defense attorney, his defense attorney was walking that tightrope after the judge said, you can't bring this in as a defense of others' defense. So the attorney was walking that tightrope of, maybe there are reasons why he did this. But for this attorney to get up and give their opening argument and say, this guy had no malice in his heart, so it's not murder? Really? This guy, oh, he was just a shining knight. He didn't have any malice in his heart. I mean, that really is the kind of argument you have to put a bag on your head to go make in front of a judge and a jury. That's just downright embarrassing. But defense attorneys have to do what they have to do to represent their client. I think that from the very beginning, their client was insistent that what he did was justified and that he was absolutely hell-bent on making that argument to the jury. So much so that he defied the court's orders and has already been held in contempt. Not that contempt is really going to matter. What's 6 more months when he's going to get a life in prison sentence? So we'll see. But he definitely is a loose cannon. He is not listening to his lawyers. He's not listening to the judge. None of that. So we'll wait to see what happens tomorrow. And with that, it is time to take some questions. We are now 2 hours and 10 minutes into this. And, I like to keep things to 2 hours. So I'm going to try and take as many questions as I can, but I don't want to keep you too much longer. So, hi, Beth. Did this guy have any type of mental evaluation? Well, I would say that if his lawyers didn't request one, it probably would be malpractice on their part. However, if you listen to this guy's testimony, he is clearly oriented to time and place, knows what everybody in the courtroom is doing, understands the case against him, and simply has taken a position that doesn't make any sense. This is kind of Lori Vallow. This is, I believe that I was saving my children from evil spirits by murdering them. I believe, see, there you go. Melanie, that's exactly right. Killing Charles, Tammy, and the children was justified because they were zombies, no malice. So I think that was her argument as well, or what she believes. Even though she was oriented to time and place, knows where she is, knows what all the people do in a trial, understands the charges against her, and is competent enough to represent herself. This guy, I think, same thing. I think that he may have diagnosable mental health conditions. He may have delusions of grandeur. He may have narcissistic personality disorder, but that doesn't mean he's not competent to stand trial. So I'm certain that at some point his lawyers tried to make that argument because he was so intractable about his position. But I think they run up against the same problem, the definition of true incompetence and insanity. He knew what he was doing. He knew that it was wrong. He knew, in his testimony, he talks about the fact that he hesitated, that it was difficult for him to hit her because he kept pulling back because he knew it was wrong. His testimony is absolutely chilling, but very clearly shows that he knew exactly what he was doing and knew that it was wrong and knew that he was doing it to Christina Purcell. He wasn't killing an alien or killing a broomstick. So, good questions. I don't recall. I hope I recall, but this is a question about Karen Reed. Didn't Brennan come back a bit later after the judge became so angry and say, oops, the date of such and such a document was 12/04/24. If so, does that change anything? Yeah, I think it does change things because it's clear that Ajax, Alan Jackson, was in contact with the crash daddies in preparation for this trial, that he did not misrepresent that he hadn't had contact with them before the first trial. And I do, and I think that had to do with an email. The document that was Alan Jackson's outline of his questions for them, which was several pages long, and which the FBI files showed that the witness had actually made notes and answered questions or asked questions and sent it back to Alan Jackson. Didn't have a date on it. So it's impossible to know when that document was produced, whether it was for the last trial or this trial. And I think Brennan's jumped to the conclusion that it was for the first trial, and I think it wasn't. So, yeah, I think Alan Jackson strikes me as the guy who's going to bring the receipts next week. And all it's going to do is make Brennan look even more foolish and whiny. Yeah. And he annoys me, you know. Hank Brennan just annoys me. He's got a whiny voice, and he's just, it's always such an affront to his integrity, and yeah, he's just bugging the heck out of me, frankly. Hi, Sharon. Did defense explain why he or the dad didn't just call the police? So apparently they did report their concerns to the police and to child welfare. He testifies, Zack Hughes testifies that at one point he called child welfare and lied and told them he was a neighbor and that he had seen this activity. But it did not result in an investigation that turned up the information. The truth about what was going on for this child actually didn't surface until after Christina Purcell was murdered. And police were investigating her murder and began to find images on her devices. So, good question. Hi, Beth. Could it be that Zack's lawyer didn't have a choice because Zack insisted on testifying and thought he was justified in the killing? Absolutely. That is absolutely what happened. The defense attorney I'm certain, has said to him, here is the best possible way for you to raise any sort of a defense. But there's not much of a defense that can be had because, frankly, he had applied for a job. This comes out in the testimony. He had applied for a job on a cruise ship doing classical piano concerts for a cruise line. And he was getting ready to leave the country to go on this international cruise line tour when he got as far as the Detroit airport, was leaving on an international flight, when he got a text message. It was unclear who sent him the text message, but he got a text message that said there was a warrant out for him. He rented a car and turned around and drove from Detroit back to Greenville and turned himself in. And there's every indication that at that point he confessed. So it's really difficult for a defense attorney who's got a guy who confesses to do anything else but try and poke holes in probable cause and try and poke holes, procedural holes, and try and poke holes in reasonable doubt. I mean, there's not a lot to do at that point. But Zack was insistent on going to trial because he believed that he could convince a jury that what he'd done was justified. Yeah, absolutely. So his attorneys didn't have any choice. You don't have a choice of how your client behaves, and they had the absolute right to make those decisions. Zack Hughes had the absolute right to get on the stand and testify, and his attorneys could discourage him, but they couldn't stop him. So you're right. So, and we've all had, defense attorneys have all had clients who insisted on acting other than in their best interest. Hi, Donna. Did it come out in trial that Zack took the money from Dad? No. In fact, his testimony was that he turned him down twice and said that he would never do it for money. He would only do it if it were absolutely necessary to protect the child. So no, he didn't. There's no indication that money ever changed hands, unlike some of these other cases like Adelson and Shana Gardner. So, any thoughts on ASAP Rocky? You know, I didn't really follow ASAP Rocky. I haven't really gotten super involved in any of these rapper RICO cases, other than at times where legal issues that came up that were really interesting, juicy legal issues, like with YNMW Melly, who has all of these issues around prosecutorial misconduct and them threatening his lawyers and all of that. That part of it was interesting to me. The prosecutor suborning perjury, all that stuff. The YSL was interesting. I only got interested in that after his lawyer got put in jail for contempt for complaining about an ex parte hearing. So I haven't really covered those. I haven't really been close to them. It did sound from the bits and pieces that I watched. I saw some shorts, but I didn't watch the trial in any in completeness. But the bits and pieces I saw, it appeared that their case was pretty thin. Their case wasn't the greatest case in the world. The injuries were minor, and there was certainly reasonable doubt as to whether or not Rocky knew that this was a gun and not a prop gun, or some kind of a video prop. So I wasn't at all surprised to see the outcome, even though I hadn't watched a lot of it, because it just sounded to me, it seems to me that there has been this concerted effort, and I'm not sure. I mean, we all know that there are some of these rap music companies, these record companies that have been screens for gang activity and for organized crime sorts of crimes. So we know that, but it seems to me that recently we've seen a real concerted effort to go after them using RICO. So whether it's Melly, whether it's Jay-Z, whether it's ASAP Rocky, whether it's Young Thug, we're seeing that more and more. And because these people are celebrities, we're seeing these really high-profile cases, these high-profile lawyers involved, lots of money, and it is pretty interesting. So I wasn't surprised with the verdict at all. Just the bits and pieces of it I saw, it sounded like their case was pretty thin from the beginning. And who knows, this may act as a bit of a deterrent for some of the other cases out there to say, hey, if you're going to go after these guys, you better have a decent case. And not something that sort of hinges on, was it a real gun? Was it a prop gun? Did anybody know? Was it, so yeah, I think we're seeing more of it. And I think it points up a lot more opportunities for more of these questions about prosecutorial misconduct and law enforcement misconduct. We've seen it in several cases, and I think that we're going to continue to see those questions. And maybe that's for a couple of reasons. One, because they're really high profile cases. And two, because these are people who can afford to get high priced lawyers and lots of investigators and really have the resources to thoroughly investigate these cases and turn over every rock. And what that means is that there's much more opportunity to ferret out things that you might not ferret out in cases where defendants are represented by overworked public defenders and have limited investigation budgets. So, good questions. Last questions, folks. We're a half an hour over our usual time, and I don't want to take up any more of your time. So please, while Jen is checking for last questions, please, if you haven't subscribed, please do so. Please hit the like button. It does help us. And please be on the lookout for some changes coming up. Changes to a little bit of rebranding, a little bit of maybe shift in direction for us. Nothing big, don't panic. We're still going to be doing true crime. It's not like I'm going to pivot to be doing fashion. God knows I'm not an expert. So we're still going to be doing true crime, but maybe just tweaking things a little bit. And we will let you know and seek your advice before we do anything. So with that, I'm going to say thank you, Jen, for sticking around a half an hour too long. And please take care of each other. Remember, the Constitution matters. And join us next week for True Crime Wednesday. Thank you, you all. I love my time with you. Good night.